Rise. Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now state the Commonwealth of Massachusetts, court is open, please be seated.
A bit high today. Good morning, everyone, and welcome to today's sitting of the Appeals Court. My name is Ariane Vuono, and I'm joined today in the panel by Justice Rachel Hershfang and Justice Gloria Tan. We have 6 cases on. Our plan is to take a break after the 4th case, but we may move that up a little bit if need be. And I want all of the attorneys and those in the spectators today to know that Justice Hershfang may stand up and stretch her back a few times during the course of the oral arguments. Don't think twice about it.
It's me, it's not you.
All right. I just want to remind everybody that we've read everything that you've given to us. The cases have all of them have many issues, and so we'll have a number of questions, I'm sure. We look forward to your answers to those questions. There is no rebuttal in the appeals court, something I always like to remind you of, just in case you're used to being in federal court. First case is 2024-0077, Ralph Amelia versus 10 Juniper Hill Road LLC and others. Good morning.
Good morning, members of the panel. May it please the members of this court. My name is Raymond Schechner. I'm here on behalf of the appellants, that is Ralph Amelia in his capacity as a trustee and Lisa Lyons as a trustee. My clients are seeking judicial relief concerning the placement of a large concrete barrier over a portion of Pigeon Lane which obstructs certain easement rights which were recognized in 1983 by the land court in a case that I'm going to refer to as Corcoran. The barrier at issue was placed there by a man named Anthony DeLosa, the former owner of 10 Juniper Hill Road and a predecessor in interest to one of the defendants that we sued in this case. The barrier was placed without any court approval and without any appropriate municipal approval. And the barrier, as placed, completely obstructed the easement, basically obliterating it. The claims that we pled in the land court were nuisance and declaratory judgment. The fundamental thrust of the allegations were that the defendants were permitting an unlawful obstruction that were basically terminating my client's easement rights. And we were seeking and are seeking an order from the land court enjoining any obstruction that does interfere with those easement rights. We're here specifically on the appeal from Judge Roberts' decision, which granted the defendants' motion for judgment on the pleadings, ruling essentially that my clients were collaterally estopped from challenging the placement of the concrete barrier by virtue of the 1983 Corcoran decision.
Can I ask you a sort of fussy appellate question about the record? In reading Corcoran, obviously there's a holding in Corcoran, and then the judge also allows a certain number of requests from the plaintiff's requests for rulings of law. This is at 78 of the record appendix, but don't distract yourself by looking for it because I can read it to you. The judge says those numbered 1, 2, 4, 9, and 13 through 15 are allowed. So there's a part of the Corcoran ruling that's not actually in the court decision itself. Are those, I couldn't find those requests for rulings of law in the record appendix. Do we have them?
We do not have them. I have not seen them. We do not have them.
Okay. So what we know about your client's rights is only what's in the Corcoran decision and does not include those additional rulings of law that the judge made.
At least as a matter of the record as it stands here today, I'm not sure if they exist somewhere. I have not been able to locate
They
any
weren't in front
further.
of the land court.
That is correct.
Okay, thank you.
What was going on in the Corcoran decision essentially was that various parties, including an entity called Pigeon Hill Estates Trust, which is the predecessor in interest to my clients and which ultimately deeded certain rights to my clients when it sold them the land, were fighting over whether and to what extent they had rights to use Pigeon Lane as the sole means to access a 57-lot subdivision which Pigeon Hill Estates Trust hoped to build. And Corcoran ruled that while the defendants in the case had easement rights to Pigeon Lane by grant, by implication, and by prescription to a very 20-foot section in the middle of Pigeon Lane, that use of Pigeon Lane to access a proposed 57-unit subdivision would overburden the easement.
I'm not sure I agree with that articulation of the court's holding. As I read it, the court ruled that the defendant's rights to Pigeon Lane are limited to an area 20 feet in width through the southern subdivisions, and the 20 feet is in the midsection of Pigeon Lane, and that the rights are for access to and from the various predecessor parcels. And then the judge says, and in addition, the proposed building of houses on 57 lots and use by their owners of the way would overburden Pigeon Lane. So that grammatical structure indicates to me that those are two sort of independent rulings. Do you agree with that?
I agree, absolutely, Your
Okay.
Honor. There is an easement right, but what was being decided in Corcoran was essentially whether the easement right was so broad that it could allow it.
Right.
And I want to, this is a very important point, because my brother on the other side, in his brief, basically says there is no easement right. There is an easement right.
Right.
It's just that the particular issue in front of Corcoran was whether, at that time, that was going to be the only road providing the subdivision, was whether that right was broad enough to support being the main access way for a subdivision, and it wasn't.
And then that's now been taken care of. There's, of course, other ways to get in and
There
out of
are
that.
other ways, and I guess I'm going to jump to, well, let's jump to the fundamental aspect of the case, which is the case was decided basically on res judicata grounds, and the court concluded essentially that it was appropriate to apply Corcoran decision to prevent this case from proceeding because the issues were similar, the parties were in privity, and offensive collateral estoppel was appropriate. I believe that's manifestly incorrect. If you go to the Corcoran decision itself, Record Appendix 0075, the decision is framed as follows, quote, "The crux of this whole case is the claim by the defendants to complete rights for all purposes for which streets may be used in the city of Waltham over Pigeon Lane as it exists today. This is after Pigeon Lane has been constructed by the developers of the Woodland Park and the DeVincent subdivision at their expense. The claimed use is to provide access to a projected 57-lot subdivision beyond the existing subdivision." Our case differs critically as follows. We are not demanding the unfettered right to use Pigeon Lane to access a 57-lot subdivision.
So what are you looking for?
We are looking for our easement rights to be respected such as they are. That is certainly lesser than opening up Pigeon Lane in its entirety for complete and unfettered use. The use is in Corcoran more limited than that. The use that would result from some opening of Pigeon Lane limited to the 20-foot easement that was found would need to be crafted in the land court based on investigation. The use would at most be secondary, and it may even be limited just to emergency access. But we believe there is some limited right of access through this road for the benefit of my clients, and that completely obstructing the easement and destroying it is in violation of my client's rights.
I'm wondering, sorry to interrupt, but what do you mean? I still don't understand exactly what your clients are looking for.
They want the barrier gone, and then they want to have use of the easement controlled in such a way so that use of the easement is consistent with the rights found in Corcoran, yet not overburdening the servient estate holders. There is, if you look in the record, there's an affidavit of Mr. AMELIA, and then there's, I actually quote the discussion I had with the land court judge. The question the land court judge has is why, after, nearly 20 years, why are you?
It's been 40 years, hasn't it?
Well, it's been, so if you,
Actually,
it was,
50.
yes, I mean, there was a break, but for a long period of time, there were certain concrete barriers that my clients had placed. He then removed them, and then this new barrier was placed. Why are you doing this?
It's for emergency access,
For emergency
right?
access. Even since we filed this case, there has been an instance where emergency services have ended up on one side of the concrete barrier trying to get to the other side. If we believe it's possible to open up just this 20-foot wide segment, control it with signage, potentially a gate, to allow some limited access, at the very least for emergency purposes. I do not believe that is inconsistent with Corcoran. We're not opening it up entirely. We're not using the entire width of Pigeon Lane, but there is some limited right of use.
Who would
which-
monitor that? How's it going to be, how would it be monitored?
I
You
don't-
think just the signage would be sufficient, and then maybe if 5, 10 years go by and it turns out that there's 100 cars passing a day through this 20-foot easement, that then,
Your Honor, this is part of the problem is, I don't know how that would be monitored. I don't know the precise nature of the remedy, but it's one of the reasons why granting the motion of the defendants for a judgment on the pleadings was incorrect. There needs to be factual development in this case of what my client's easement rights are and how this might work going forward in such a way that it would not necessarily overburden the Servian estates. We are without any record, without any factual development, and instead the court basically just views it as mutually exclusive. I mean, that it's impossible to open it up in any such way without overburdening it. I don't believe that's the case. And if it is the case, if after a trial it was concluded to be, then so be it. But it's not a conclusion that can be reached on a motion for a judgment on the pleadings. So
This seems like a case that would be ripe for some kind of non-judicial resolution. I trust that has been explored.
it has been explored, Your Honor. It has been explored, Your Honor, yes.
So just so that I'm clear, your clients are not necessarily looking to use it for everyday access themselves. You've stated that really, the motivation is really for emergency access.
I mean, that is the primary motivation. What could be used and be consistent not only with the rights found in Corcoran, but also not overburden the Servian estate holders, needs to be developed factually before this matter can be concluded. But essentially, yes, I agree. We are looking for something much less than full, complete, and unfettered access. And full, complete, and unfettered access isn't even necessary. It was necessary in the Corcoran decision because there was no secondary access. Secondary access, which is now primary, has been provided. Not that it's necessarily dispositive in any way on a motion for judgment on the pleadings, but we did provide a traffic report saying even if it was open for full and complete unfettered access, which we're not requesting, but even if it was, the use of this would be 40% of what it would otherwise have been without the initial access.
But still substantially greater than the historic use.
Sure, and that is why,
yeah.
I state that just because, there's really two prongs here. One is that the issues are not exactly the same, and the other is that there have been some material facts that have changed since Corcoran that would bear on the analysis. And both of those together strongly suggest that whatever the ultimate result should be, it needs to be made not on a judgment for the pleadings, but it needs to be made after factual development. That is really the fundamental thrust. I'm going to further point out, as I said in the beginning, that placement of the concrete barrier by the predecessors in interest to the defendants was never court-approved. It was total and complete self-help. And the closest case that I could find that provided guidance on what the SJC suggests is appropriate in situations where the servient estate holder wants to potentially move or modify the easement at issue is the MPM Builders case. And in the MPM Builders case, the SJC puts the onus on the servient estate holders to, if they're going to impact the easement in a significant way, for them to bring the court action. Please, you can go to 442 Mass 93. Servient estate holders are required to seek a declaration from the court that proposed changes to the easement are permissible prior to making changes to the easement, and changes to the location of the easement may not significantly lessen the utility of the easement, increase the burdens on the owners of the easement, or frustrate the purpose for which the easement was created. There is an easement. It is certainly more limited than full and complete access, but those rights are not nothing, and the placement of a concrete barrier completely obstructing those rights is, my clients submit, not appropriate. Any further questions?
Not here, and we're here. Thank you very much for your argument.
Thank you.
Good morning, Your Honors. Richard Leclerc for the James Sweeney and Emily Sweeney, trustees of 104 Pigeon Lane Realty Trust.
Could you hold on for just 1 minute until the clock resets? You, sorry. Thank
Richard
you.
Leclerc for the appellees, Your Honor. Your Honor, the land court properly decided this case on the basis of res judicata. There's no need for any evidence or an evidentiary hearing to determine the easement rights in this case. The easement rights have been determined. The plaintiff went into land court saying, I have easement rights as a result of this earlier case 40 years ago. And the court had a trial and determined those rights, and they're in that judgment. And the court at the same time said, those easement rights do not include accessing this 57-lot subdivision. That's all they're talking about doing.
Well, I want to be very clear about that, because it does, I'm sorry, that nobody could ever understand that. The Corcoran decision does say that the plaintiffs have a right to access the 57-lot subdivision. It also says that all those other lots do not have that right.
That's correct. Well, what it says is, what it says specifically, and what this court said, what this appeals court said, the proposed loading onto the easement access to 57 residences manifestly overloads the light horse cart use and camp visiting use for which the easement was required. That's this court decided that.
Right.
So there's,
years ago.
go ahead.
40
But
years
this
ago.
isn't a class action.
I understand it's not a class action.
So we're only talking here, I understand the world is the world and there are consequences, but the legal issues here pertain to the plaintiff's rights.
That the plaintiff's rights are covered by that decision, because if you take away the barriers that block this road, and it blocked this road for 40 years, I grew up in this neighborhood, actually walked through the old Camp Ted to high school. You take away those barriers, you have access to the 57-lot subdivision. Whether it's 1 or 100 people using it, doesn't matter. And that was addressed, the arguments they're making
But
today
what's not been addressed is that 20-foot wide easement that is then established, that now is worth literally no passage whatsoever because of the barrier, right?
Justice Vuono, you need to remember, the rights of these plaintiffs in particular are less than the other people because they only have the prescriptive right, which was to use Camp Ted on a seasonal basis and for a caretaker to access it. They have those limited rights to use it on a seasonal basis. So those are the rights that, if they have rights, I'm going to argue in the end that they don't have any rights because the deed they received reserved the fee in these roads and didn't grant any easement rights over this. The judge in the land court assumed they received rights from their predecessors in title. But if you look at the deed, the Pigeon Lane Trust, which they take title from, actually reserved the fee in Pigeon Lane and granted easement rights not out to Forest Street, but out to Harrington Road, which was the ultimate access that they used. But if you look at the decision, it's the overloading of that subdivision onto this that overburdens it. And that's exactly what the appeals court held. And they got into that discussion. They made that argument in the appeal 40 years ago. Well, if we use it, you didn't break down how many times we can use it. Is it limited to 10 trips a day? Is it limited to 15 trips a day? And the appeals court said there's no need for it. It's the nature of adding 57 lots to this Pigeon Lane, this easement rights, that changes the nature of those easement rights, that overburdens those easement rights. So to open this up at all would be an overburdening. In the court, to have have somebody there to count the number of people go through, the court held before, this court held before, that's not necessary to do. It's the nature of the use, the proposed use, that overburdens it. They make the argument, and he said, well, they only did it because it was the sole use. You do not find in the land court decision that they had any discussion that it was going to be the only access. That's just not there. It's the nature of the use. And in the second means of egress even makes the situation worse, because not only do we have overburdening, you're adding 20 additional lots that have no argument that they're part of the chain of the title that may have easement rights.
So you're saying that there's just no way that the easement can be limited without some sort of a barrier.
Correct. It's just allowing access through there on that road would be a violation.
And why doesn't that need a factual record to support that?
Because we already have the factual record. We already have the determination in the earlier decision.
If we were to read that decision in a more limited fashion, for example, hypothetically, okay, that really what's going on there is that you would clearly be overburdening the easement over Pigeon Lane if you're talking about building those 50 homes or 53 homes at the time, whatever it was, and that being the sole road in that subdivision. I think a main issue at that time also, of course, was construction vehicles and things of that nature.
That was, I mean, this issue basically comes down to the old plaintiff saying, look, we own this, you don't have the right to use it. The court found those limited easement rights, but the court and the appeals court said using those easement rights to access a 57-lot subdivision would be an overburden.
What can you use the easement rights for?
Well, they can't, the court has already held, they can't use the easement rights to access the 57-lot subdivision. So therefore, I would suggest to the court.
Let's say that's agreed, okay?
Yep.
Well, then.
They have no other rights.
What rights would they have to get through that barrier? How do they get through that barrier to have any of those rights?
Well,
what rights, could you be more?
But they don't
help me out
have.
here. What are, in your view, what do they have?
Reading the decision, they don't have the right to travel over Pigeon Lane, east of the barrier, to get into that 57-lot subdivision. That is what the court has found is an overburdening. And so, as a practical matter, I think Justice Tan raised this issue, there is no other way to monitor this. It's just not one plaintiff. If you open it up, everybody has access, and now you even have people that have no easement rights. The 22 additional lots they added, they have access over it. So you not only have overburdening, you have overloading. And Justice Hershfang, you raised an issue, and two things that aren't in the record. There's no evidence in the record that there's been any emergency issue. That's not in the record. This has been this way for 42 years. Everybody in Waltham knows that this road, the Pigeon Lane, there's an east and west. But there have, and because it's not in the record, and I don't want you to think, there has been an offer. I sat in the office with the mayor of Waltham who said, I will put up a gate and give the key to the fire department. Everybody okay with that? Fine with me. Wasn't fine with the plaintiff. So that's not in the record, and I don't want this court to consider that because that's not an issue. If there was a gate and the key and the fire department had it, my clients wouldn't have an objection.
Can I go back to, are you done?
But let me just, before,
Sure.
These issues about non-permitting and not having the right to do it, that's for the city to enforce. That's not what this case is about. This case is about, does the plaintiff have the right to use that easement rights that were prescriptively obtained to access a 57-lot subdivision. The land court said they couldn't in 1982. This court said in 1983 that they couldn't. The land court has repeated that in 2023, and I asked the court to find again. This case has been decided.
I'm trying to figure out how what you have just said squares with the words on Record Appendix 77, which is the land court decision in Corcoran, which says, "The court finds and rules that the defendant's rights to Pigeon Lane are limited to an area 20 feet in width through the Woodland Park and DeVincent subdivisions, so south, the 20 feet located in the midsection of Pigeon Lane as laid out on the subdivision plans, and that these rights are for access to and from parcel A by grant," not our problem today, "and parcels B1 and B2 by prescription." B1 and B2 is our plaintiffs here today,
Correct.
right? So how is that part of the holding of Corcoran reconcilable with the notion that these plaintiffs have no right to drive north from whatever this southern subdivision is?
Because, Your Honor,
Woodland Park.
those rights were to access a camp on a seasonal basis.
So let's say they only come in once and, on July 1st, and then they leave on July 14th after their 2-week stay.
So that would be okay, but that's
But they
not.
can't do
But
it.
that's not what has occurred. What has occurred is the construction of a 57-lot subdivision and attaching that to that easement rights that the court found. The court found that reality that didn't exist then, but that exists today, is an overburdening. So there has been any.
But no one's
So
giving
you-
them the right to use it.
I'm sorry.
No one is giving those 57 homes, the people who live there, the right to use it. As Justice Hershfang is pointing out, we're talking about the owners of B1 and B2, those parcels.
I'm sorry, Your Honor, I could not hear.
The Boy Scout parcel. In other words, your argument seems to rely on the notion that if the plaintiffs are afforded the rights that they say they won in Corcoran, by definition, the 57 other lots, which I understand now is 72 other lots or 71, also have those same rights. And as a practical matter, I don't disagree with you, but as a legal matter, that actually is not true. There's a distinction in the Corcoran decision between the rights in the owners of the former Boy Scout parcel and the rights of the people who are going to own these other lots.
Correct. And if those uses had continued by those defendants of accessing for a camp and access in the Del Pines carrying their wood to their home, if those rights had continued, they'd still have those rights. But the fact of the matter is, those rights don't continue any longer, because what they did was build a 57-lot subdivision and connect it, which the court found that providing access to that 57-lot subdivision is overburdening. The court didn't say 6 cars can go or 10 cars can go. It's the fact that you've connected it to a 57-lot subdivision, the nature of the change. It's no longer accessing a camp. It's no longer gathering firewood. It's access to a 57-lot subdivision. That change is what is the overburdening, and that's what exists today, and that's what they're asking to do.
But no,
And
you're
this-
correct. Apparently, they're not asking to do that. They're just asking to have access to their 20 feet in the middle of Pigeon Lane. If they're asking for more, it would be problematic,
But they're-
right?
No, they're asking to access the 57-lot subdivision. It's that access that is the overburdening, and that this court.
Even by two owners of two parcels of land.
Correct. That's what the decision says. And I'm certainly the court recognized that you can't police it. You can't say, okay, and they raised that. It's not the number of trips.
I'm not so sure the court said that you can't police it or things of that nature.
This court certainly said it. It said there's no merit to the argument of the defendants. The judge was required to calibrate what manner of use Pigeon Lane by the defendants could constitute with their easement. There wasn't a need to the court to calibrate it. This court has already decided that. This exact argument was made 40 years ago. And but it's the access, it's the fact that you're crossing over that 20-foot strip to get into a 57-lot subdivision. That act is the overburdening, and that's the act they seek to do.
But your opposing counsel's claiming he's not seeking unfettered access necessarily, right? He maintains that it's for emergency access only,
Well, what
which
they're
might
ask-
sort of go to your overburdening concern.
What
which I
we're
understand.
asking for is for the removal of the barriers, which would then allow people to access the 57-lot subdivision over this 20-foot easement, which has been found to be an overburdening. It's not, they didn't get into the number of car counts. That argument was made and rejected by this court 22 years ago. Your Honor, I'd like to just point out one thing. The plaintiff and the land court assumed that they were successors in interest to those prescriptive easement rights. But if you look at the deeds that they take title from, the defendants in that old lawsuit actually reserved the fee in the roads and didn't grant any easement rights out over Pigeon Lane to Forest Street. They only granted them over to Harrington Road. So I respectfully submit that these plaintiffs don't even have any rights to avail themselves of.
Well, yeah, I found this really weird, but whatever. They reserve the fee in Pigeon Lane and Lisa Lane abutting the aforesaid lot. So I'm not sure that's reserving the,
Well, that's the Pigeon Lane that comes down. The road does run directly down.
but it's right in front of their lot, right?
Correct.
That's what abutting means.
That's the Pigeon Lane they're referring to.
And then they grant the right to use it, as you say, going north to get out to Harrington Road.
Harrington Road, not out to Forest Street.
And I assume Ralph P. Amelia. and-
Same person.
And Felix Pittarino is the same person?
Yes.
Okay.
Right.
But Your Honor, if I could
Your time is actually up, so I'm just see if the panel has additional questions. And I don't see, so thank you very much for your argument. Thank you both.
Thank you.
Okay. The next case is case number 2024-0117, Tony Rodriguez and others versus members of the Brockton Zoning Board of Appeals and others. Okay, good morning.
Morning, Your Honors. If it may please the Court, my name is Matthew Ezepek. I'm here on behalf of the appellant, Tony Rodriguez. As you've read the papers, this is an appeal of Mr. Rodriguez's Chapter 48, Section 17, appeal. Brockton zoning decision. Actually, two zoning board decisions. First, allowing the use of a packaging warehouse in a residential zone. A dairy decision. Continued non-conforming use, not deviate substantially from the existing non-conforming use, which was a cabinet-making company. So Mr. Rodriguez's claims were dismissed in two summary judgment decisions by the land court. The first summary judgment decision decided that Mr. Rodriguez lacked standing on three of the aggrievements that he had proposed, those being noise, odor, and overcrowding/density. That decision maintained that he did have standing on the limited basis of traffic, and a subsequent summary judgment decision entered later on determining that he lacked standing as it related to the traffic issue as well. So you've read the papers. I'll try to keep it brief and answer any questions. But effectively, for the first three issues that I raised, we just find that the court got that wrong. There's no real dispute as to the law here, and as mentioned, to rebut the presumption that Mr. Rodriguez had as an abutter to this project, 555 Plain Street in Brockton. There were two manners of doing so. One, to show that the alleged aggrievement does not fall within the harms protected by the bylaws, and that was not at issue in this case because the court had determined that each of the aggrievements proposed by Mr. Rodriguez specifically fall within those bylaws. So the second manner in which the defendant in this case could have, and apparently did in the land court, rebut the presumption of Mr. Rodriguez's standing was to provide affirmative evidence that Mr. Rodriguez did not have a particularized aggrievement as it related to this project. So first focusing on the noise issue, the lower court decision focused strictly on the 20 by 40 walk-in cooler addition at the Plain Street property. So in addition to the use variance that was allowed to allow Jordan Seafood to operate at this residential lot, both of the petitions that were allowed by the City of Brockton Zoning Board of Appeals authorized a construction of this 800 square foot cooler to be added to the back of the building, the area that really is closest to Mr. Rodriguez's property. So the summary judgment decision focused strictly on that issue, and the court found, without really any expert testimony on either side, that the noise was not significant enough for Mr. Rodriguez to have standing.
You found it was, in fact, equivalent to the noise level of a residential air conditioning unit, right?
That is what the court found, yes. And that, I believe that was based on the affidavit of Mr. Jordan himself. However, what the summary judgment decision did not address whatsoever was the other aspects of the noise and...
Well, let's start with it. Let's go back for a moment to the proposed storage unit. Is there any disputed issue of fact with respect to whether or not the noise level with respect to that storage unit, 20 by 40 feet, is more than or less than the noise that would be produced by a residential air conditioner?
Well, I think there was a disputed fact, Your Honor. And again, the level of evidence...
Other than just saying we don't agree? I mean, where was the...
Right. So Mr. Rodriguez had written an affidavit. He had answered some questions, identifying that he had went to the existing operations of Jordan Seafood. And this is a cooler that is identified in the record as being the same cooler that's in operation currently at their existing operation. So I believe when Mr. Rodriguez testifies and answers questions that he has viewed that, he's listened to that, and he identifies that there's a noise issue relating to that cooler. I think that does create an issue of disputed fact. Now, again, the quality of evidence on both sides in the summary judgment record was not substantial. One side saying it doesn't cause much noise, and the other side is saying, I've heard it, and I believe it will cause noise at my property. So in that circumstance, it seems like the judge in the land court just decided to agree with one side's interpretation of the noise level, which is on a summary judgment level, I think was inappropriate. I mean, if this was a trial, obviously, and there had been a walkthrough or a walk at the facility to determine what the actual noise level was, perhaps at that stage there wouldn't need to be any sort of expert testimony. But at the stage of summary judgment, to just kind of conclusory say there's no noise produced, or is that of a residential air conditioner for an 800 square foot storage unit, when that is disputed by the appellant here.
There was also a condition in the variance that limited the noise from the refrigeration equipment. Why doesn't that extinguish the presumption, or at least shift the burden back?
Well, again, I think that just comes back to, even if it did shift the burden, I believe that my client, it was undisputed in the record that the existing refrigeration unit is going to be the same one used at this particular property.
No, I heard you about that. Did your client's affidavit include any measurement? Did he take a decibel meter out there and measure the current unit?
No, he
Is
did
that
not.
in the record?
He did not. That was not on the record. So again, as mentioned, the quality of evidence on either side I don't think was tremendous. But the summary judgment record did not address at all the noise issues created by the delivery trucks, the delivery vans, the hauling in of 400 pounds of fish per day. I think in my
Well, that would be part of the traffic part of the traffic considerations, right?
that's part of the traffic concerns, but it's also part of the noise concerns. These are refrigerated trucks, is my understanding. And again, this wasn't really addressed on either side of the case because there was no affirmative evidence offered by the defendant on the summary judgment record as it related to the noise.
Well, what was your burden to present affirmative evidence of some of these issues?
At the initial stage, there is no
Well,
burden.
after, once the presumption was rebutted, what was your burden?
Well, I think that the argument,
I know you're saying that the presumption wasn't rebutted, period, and so therefore you never had that burden.
exactly. And even if it was rebutted, then there would be the obligation to provide your own affirmative evidence as to what the harm was. And again, I think even if the presumption was rebutted here, Mr. Rodriguez in his interrogatories, in his affidavit, again reflected that he's gone to the property. I think in my opposition, my brief, I referenced 9 to 10 commercial vehicles going there per day.
So I have a question about that. Am I correct that it's 5 pickup trucks and 4 vans that are being proposed in terms of what the expected traffic would be?
That is my understanding. However, I may have been underestimating that a bit because the court actually found in the summary judgment record there's going to be up to 12. There are 12 vehicles registered to the company, so the presumption at the summary judgment record was actually that 12 commercial vehicles will be going in and out for deliveries each day. So those issues, the idling of the vehicles, the exhaust, everything that Mr. Rodriguez had testified to about his concerns relating to the noise that those delivery trucks would cause was not even addressed on the summary judgment record. It was just...
So I thought the record included the following facts, but you tell me if I've gotten this wrong. That the trucks come in once in the morning, early in the morning, and then they're loaded up, and then they go out once later in the afternoon, and then I guess they don't live there, because if they come in the morning, then they've come from somewhere else. Am I right about that?
That is correct. And
So let's call that 24 trips, because it's, twice by 12 trucks. And I know that state law limits engine idling time to 5 minutes. Was there any record about whether they were going to violate that, or there was any reason in the record to believe that would be violated?
I don't think that was in the record on either side. That wasn't presented on either side as to what the exact idling time would be. The only issue would be that these are, again, refrigerated trucks. So when these are being loaded and unloaded, they would need to be on for the refrigeration unit to be working, would be my understanding.
Also, the defendant retained an expert who produced a report, right, that was considered. And on the issue of traffic, in that report, Table 4, he does a comparison, right, of trip generation comparison.
Yes.
And he finds in comparing the previous uses of that location, that in fact, so it was a church, and then it was a plumbing warehouse and workshop before. And that looks like also, and so comparing those previous uses, the church and plumbing, the expert maintains that it's actually going to be fewer trips daily, right, than those previous uses. And in fact, in his calculation, he indicates that the increase in traffic would be less than 1% on weekdays and less than 2% on weekends. Is that not de minimis?
Well, as far as the expert report went, we did have a rebutting expert report that questioned the methods and calculations that were used to obtain that data. So that was part of the opposition to the summary judgment record, that data should not be considered or included. And
didn't the judge, though, in the lower court, during that hearing in which the reports were discussed, he asked counsel whether it was okay to go forward considering these reports, and both counsel attorneys said yes.
Well, I was definitely counsel for that second summary judgment hearing. I don't recall that.
It's in record appendix. Let me see. Give me a second.
I could be wrong, but I would disagree with that just because
Volume
effectively
the record appendix to pages 189 to 90. Yes, should we proceed? And I'm paraphrasing, and I can find it for you in 1 minute, but the exact wording. But both counsel agreed to go forward in consideration of these two reports. Just so you're aware, your time is...
Oh, sure, just reading that piece of it. I believe the question from the court was, is it okay to go off of the reports rather than affidavits? And that's what counsel was okay with, rather than, so that was the only thing, was that we weren't suggesting that an affidavit was needed. And if I could just be heard on a legal issue as it relates to the density and overcrowding issue that I just completely disagree with on the lower court issue. The density overcrowding issue was determined largely on the law stating that the issues that were raised by our side as far as the bylaws, the expansion of this building, in violation of the city bylaws, the non-conforming use cannot be expanded beyond 50% of the original use. The court determined, well, that's really a use issue. That's not anything as it relates to the underlying bylaws for non-conforming use. So legally speaking, they said that was no good. However, the bylaws in question are designed to ensure that there's not overcrowding by allowing an expansion of the use. So I think it did fall within that bylaw issue, and I explain it in more detail in my brief. But I just wanted to point that issue. That's the one real pure legal issue that we have in this case.
Understood. No further questions from the panel. Thank you very much.
Thank you, Harris.
Okay, Mr. Jordan.
Good morning, Your Honors.
Good morning. I'm going to ask whether or not you have argued before the appeals court before.
No.
I didn't think so. Welcome to the
can
appeals
tell.
court. The only reminder I'm going to tell you is that everything we hear from you has to be in the record.
Yes.
So that's the only important thing to remember as you deliver your argument this morning.
Questions. Just want to address the vehicle situation.
Sure.
We do have 12 vehicles registered under Jordan Brothers Seafood.
I'm just going to ask you to talk into that microphone
Yes.
too. Yeah, thank you.
7 of them are pickup trucks with slider chiller boxes in them, refrigerated. The other ones are personal vehicles for salespeople / my wife, my daughter, my son, and a hobby car. So there are actually only 7 vehicles operating as Jordan Brothers Seafood, transporting back and forth.
What is the hobby car?
A 76 Ford Elite.
That's fabulous.
Yeah, my high school car. Basically, just looking to expand our business 6 or 7 years ago into a building neighboring Brockton. We are in Brockton now. And basically, this case has been going on 6 or 7 years. When it started, I had 2 grandchildren. I now have 7. This is primarily, in my opinion, just a case of a budding neighbor that doesn't want an operation in his backyard. I understand that, but we went through the proper channels with 2 zoning board approvals, and the reason why I'm pro se now is because I've exhausted all my revenue fighting this case, well over $20,000 in attorney fees, $8,500 in a traffic survey, which is being poo-pooed, and Mr. Rodriguez is on his 3rd representation. That would perhaps explain why there is not a lot of evidence available to you folks. And basically, that's all I have to say.
Okay, I'll see if the panel has any questions of you.
Just a quick question, so about the dumpster, because at one point in your affidavit, you indicated there would not be a dumpster on the premises.
Yeah, currently at our facility, we have 1 barrel that we throw our trash in, and then we have barrels that are picked up weekly. We also keep them in the building until the day of the trash pickup, and then we monitor them, believe it or not, so nobody throws trash in them once they're emptied. And we just pull them back in. The time that Mr. Rodriguez came to our facility, he accused us of staging the facility because of its cleanliness and lack of waste. And that's how we started our relationship, unfortunately.
So you will not, the plan is not to have an outdoor dumpster? And
Not at all.
I know I saw on the record that you indicated that all waste would be kept inside in the refrigerated until the trash, I guess trash day
Exactly.
comes or whatever, and then you
Yes.
put it out then, and then, so there would never be any outdoor
Nope.
waste?
No, it's actually a nuisance for us to police it. So
Sorry?
it's a nuisance for us to police it because, you know, obviously there's raw seafood in there or something like that. Trimmings, basically. So we govern it very well, and we keep it in our own facility until they come by.
Thank you very much. Thank you both very much for your
Thanks for your
arguments.
time.
All right. And our next case is 2024-0018. Do I have that correct? Sunpin Energy versus Donald O'Neill? Yeah, okay. I'll read the full title of the case again. Sunpin Energy Services, LLC versus Donald O'Neill, member of the Petersham Zoning Board of Appeals et al. And Roberts, et cetera.
Good morning.
Morning.
I'm Jim Martin, counsel for the appellants. At the outset, I'd like to make 3 points to draw attention to the position we have in this case. The first is that the SJC decision in the Tracer Lane case directly controls this case.
Okay.
The board's decision amounts to a de facto prohibition on large-scale solar in over 99% of the town in Petersham. Second point is that a solar project is entitled to heightened protection under Chapter 40A, Section 3, Paragraph 9. The normal special permit process does not apply to a solar array review. A special permit for a solar project may be conditioned but not denied, except in very rare instances which are not present in this case. And the third point is that the only basis in which a local board may prohibit a solar use is where it is necessary to protect the health, safety, or welfare under standards established by the bylaws, not by an individual member of the Zoning Board of Appeals.
So you're referring only to Section 18?
Pardon me?
Only Section 18 as far as you're concerned?
Correct, Section 18.
Can you explain to me before you go on, when you make that assertion that a special permit may be conditioned but may not be denied? I think I heard you say, correct?
Correct.
All right. But if it is in contradiction to Section 18 or in contradiction to the health, welfare, and safety of the public, it can never be denied? I mean,
Oh, obviously
okay.
not never. That's
All
why
right.
I said, except in rare circumstances, it may be denied.
And in your
so
view,
it's not never-
what circumstances might that be?
Well, there are none in this record or this case.
Well,
but-
I understand your
but as
position.
a hypothetical, it could be that it was overburdening a community's power grid such that it couldn't deliver services to the community. It could be that the location of it was impeding or threatening a particular vital resource that.
So in your view, for example, the fact that this is a forested area and close to other recreation areas does not qualify?
Absolutely, does not qualify. The town is 99% forested. If you were going to restrict it from forest land, you would not, it's a de facto denial of any solar in the town. The project underwent.
I didn't see that in the record. Where in the record does it say that? Did you say that 97% of the entire town is forested? Is that what I heard you say?
It was, I can't cite in the record, but
Okay.
it was, I was at the hearings.
I mean, I know that this area is forested, for
Yes.
sure.
Yes.
I think it was in the Reynolds decision,
Okay.
Okay, thank you.
but I might have made that up.
So I don't think there's a dispute. In fact, there's no material facts in dispute in this entire case. Petersham has a bylaw, Section 18, that addresses clearing of vegetation and trees as part of a special permit. It's fundamental to start with that. Petersham addressed the issue of large ground-mounted solar arrays in their town by passing this bylaw. It was done at a town meeting, it was approved by the Attorney General, and it laid out very carefully and balanced approach to what factors would be taken into consideration for the approval of a zoning bylaw. It has vegetation and tree clearance provisions in there that said it must be they must be carefully calibrated and done only when necessary to install the
Right.
solar.
I'm just trying to understand some of the parameters of this case, and I know that I'm asking some questions that are I'm not necessarily present here. But I've read that, and so, of course, it requires only as much tree clearing as necessary to construct the project. But what if we were talking about, for example, 80-foot timber, 2 feet apart, all in the whole 14-acre area that we're talking about? Can't imagine why anybody would want to clear that much at that kind of expense. But let's just say, hypothetically, would that then contradict at some point that particular provision?
I don't think so, Your Honor. First of all, this is private land. It's a 24-acre lot. The owner could come in and clear cut that without any permits, without any approvals whatsoever. So he is free and able to do what he wants to do with his land and under the bylaws. And so the fact that these were tall timbers bunched together doesn't necessarily change that approach. What the bylaw says is when necessary to construct the array. And in this case, as I started to say earlier, we underwent a very rigorous Conservation Commission review hearing, which is in the record. The Conservation Commission review, I think, met 4 or 5 times. They issued an order of conditions. Sunpin accepted the order of conditions, allowing buffers, allowing reduction in cutting, allowing raising of fences so that wildlife could get through, setbacks to protect any potential wetlands. So that rigorous process did go through in terms of meeting Section 18 as to minimizing what needed to be done in order to do that. Why have a bylaw that allows for large ground-mounted solar if you're not going to allow it because you don't want any trees cut in your community? There is a very small 5-acre parcel which doesn't even fit the definition of Section 18 because it's too small. It's owned by the town. This bylaw has been in effect for a long time. Petersham's never issued a permit for a large ground-mounted solar array, despite the approval of the town to do so. This is the case now that is bringing this matter to a head in this town. It's a de facto denial of having solar in the town. The dissenting member's decision makes that quite clear. She ad hocly, brings up reasons why, none of which are in the bylaw, none of which are in the law. It's outrageous, frankly, that, worry about the cascading effect that if we let this in the door, this case, then more might come. That's not in the standard, that's not in the law, that's not in the case law. That's just an individual dissenting member saying, I don't want trees cut, I don't want anything, any solar in town, and I'm going to deny it. The majority of the board approved of this decision. The majority of the board wrote a rational decision that put conditions on the project, which are reasonable. So when I say reject versus condition, the majority of the board did that. So Petersham's bylaw contains balanced clearing standards. The ZBA, and certainly not a single member of the ZBA, can impose extraneous health, safety, and welfare standards to prohibit a solar project. But I'm sure you justices know from reading the record, there's no evidence from the ZBA or from the dissenting member of any health, safety, or welfare issues in the town as a result of this project. They are policy decisions. And, you know, the Commonwealth has made it quite clear through its courts, in the Tracer Lane decision I earlier referred to, and in policy statements that we have a goal of getting to try to be an energy balanced by 2050, and that solar plays an important part in that. And without that contribution and a balanced approach, we're never going to get there. And we need to look out the window today and around the world, and we see that we need to get there. And so to ignore that goal and not allow a balanced approach is incorrect. Now, in this situation, you know, we have the trial court erroneously giving great deference to the ZBA in denying this petition and therefore granting summary judgment. The board does not have that discretion. We cited the case law that establishes that. In the solar case, the protected rights that the statute provides and that the Tracer Lane decision provides make it very clear that that is incorrect to do so. It
So
doesn't
basically,
have
your
to-
point is, once the criteria in Section 18 is met, then the board has no discretion
Once the criteria is
of the
met-
special permit, which is basically the bylaw of Section 18.
Right, that is our point. But in real estate law and presentations, there's a difference between, you know, something that has site plan review versus what something must be approved with conditions. And in that case, our position is that solar, except in the very rare instances which don't exist here, can't be denied. It can be conditioned. And it's like a site design review. You have to move that road here, you have to do this here, you have to plant this here. You can do that, but you can't deny it. And that's both public policy by the legislature and the town and the bylaw.
But you're not objecting to the fact that, I don't understand you to be objecting to the fact that a special permit is required, given the large-scale aspect of your project.
I think the case law is clear that a special permit can be required. We're not
Yeah.
challenging that premise that you can't go through the special permit process. But the special permit process must be limited in scope to conditioning the permit and determining and providing for health, welfare, and safety. There is nothing in this record from the town, from the board, even from the dissenting member that suggests that there's any issues with regard to health, welfare, or safety. The use that the deference that the trial court did in granting the preamble statement of any bylaw I've ever met, that this is to promote health, welfare, and safety in any community, is as a preamble. In the actual bylaw, Section 18, it also addresses that, and it lays out standards for that. And this project completely complies with those standards in terms of, and there's no evidence that there's any health, welfare, or safety issues to the citizens of Petersham by allowing this project. What we heard, what we read, what the court gave discretion to incorrectly and gave deference to was the conclusion that unless the board acts arbitrarily, she can't overturn it. And that is just plainly wrong. Because of the special deference that the courts have granted on solar arrays, and because it's a two-pronged standard. You look at it, and there's no evidence of any health, welfare, or safety issues. whether or not citizens have complained about, or not even complained, excuse me, have expressed some concern that there may be growing the size of the town, that there is, other issues that the dissent member identified, which had nothing to do with health, safety, or welfare. It was purely commentary on quality of life in terms of how the dissenting member viewed it. The land courts have repeatedly ruled that solar is a protected right. This court is well acquainted with Tracer. I won't go into that. But this court has also recently issued a decision in August. I just had it here, excuse me a second, in the Kearsarge-Walpole case, which we cited in our brief before it was decided, supporting our position. And in Walpole, I'm sure you know, the court ruled in favor of the developer, saying that under 40A, Section 3, Paragraph 9, Walpole couldn't impose a blanket prohibition on large-scale solar outside of a fairly minuscule solar array district. The town did not establish that its interest in preserving the character of an agricultural and rural residential district was sufficiently compelling under Section 3 to justify that prohibition. Here in this town, as we've said, it's heavily forested. The single member has said that that in and of itself is a reason to do it. And with time ticking away, I'd like to address our request for a remedy in this matter. We believe that this court should issue a judgment in favor of this project, and the reasons that we feel that this is warranted is because to send it back to the planning board, the zoning board, is futile, and it avoids the inevitable outcome in this case. The town itself, through its council, in the papers at the motion for summary judgment and cross motion, said, don't send it back to the trial court. The outcome's going to be the same. The dissenting member has said, I'm not approving any projects that involve tree cutting. So this project has been going on for 4 years. I felt sympathy and empathy with the gentleman who just appeared before at the length of time, the cost, the lost opportunity to bring this solar energy online for the citizens of the Commonwealth to enhance the ability to meet the goals, all warrant that this case should have a judgment entered in favor of Sunpin and not send it back to the board to, go through steps that are going to be are futile, and the outcome is going to be inevitable based on your sound reading of the law. Okay?
Let me see if the board...
Any other questions? Thank you very much.
No questions. Thank you very much.
Good morning. May it please the court, David Doneski for the defendant, the Petersham Zoning Board of Appeals. In the last few moments, my brother referred to this court's decision in the Walpole case several years after the land court decision that's cited in the papers and referenced a virtual ban or prohibition. There's nothing like that in this case. There are two main sources of authority for this court to consider, obviously the Tracer Lane case and this court's opinion in PLH v. Ware, where the court, as my brother has acknowledged, agreed and endorsed the concept of a special permit for a solar energy system, even under the regime established in Section 3 of the Zoning Act.
That's an unpublished decision.
Yes.
Yes,
PLH
that's
decision.
correct. But I would submit there's no dispute, and Tracer Lane does not speak to that. Tracer Lane stands for the narrow proposition that where the Waltham Ordinance would allow a large-scale solar in only 1 to 2% of the land area of the city, that was too much of a burden to withstand scrutiny under the protections, encouragement, if you will, that Section 3 provides for solar energy systems. And again, there is nothing like that here. Ground-mounted systems up to 10 kilowatts are allowed everywhere in the town. Greater than that, they are still allowed everywhere in the town by special permit and allowed without a special permit and by right in the solar overlay district.
Which, of course, is a very limited area.
It is, Your Honor.
So let's just talk about the rest of the area. And if it's all encumbered or blessed, whichever way you want to put it, by trees and forests through the majority, how would a project like this ever get off the ground? Not to be, no pun intended.
Each case has to stand on its own, and my brother said the town has never approved a large-scale solar. Well, this is actually the first application for large-scale solar.
Okay.
So you can't make a rule based on one decision. Now, every site is not going to necessarily require, and the appellants have not demonstrated or shown that you could not make an application anywhere outside of the solar overlay district that couldn't satisfy the concern of clear cutting that is expressed by the statement of reasons that by virtue of the Zoning Act becomes the majority decision here.
So can I just ask, the reasons for denial by the one dissenting member, there's actually one of her paragraphs is titled General Discomfort Generated by the Commercial Activity in a Residential Area. And the reasons that she gives include noise, tree clearing, property values effect, vast unbroken forest. She doesn't want to go down this trajectory, where understandable concerns, right? But nevertheless, where natural lands are fragmented and more businesses, more houses would then come in, more development. How do these reasons affect the public health, welfare, and safety?
I would not ask the court to endorse all of the elements in the statement of reasons, and I think the reason that we are here, is the clear cutting that's proposed by this project, which is completely contrary to state policy to site these systems in non-treed, non-forested areas. The court asked the question about what in the situation of a vital resource, and the appellants essentially said that forested areas are not a vital resource. That also is completely contrary to state policy and to the very same ideals that the appellant is asserting and with which the ZBA does not disagree, that we must address climate change. The Supreme Judicial Court has said it is a present threat. So the question is it appropriate for purposes of creating a solar energy system to destroy one of the very resources that helps protect against climate change, and that's the forests that provide carbon storage? So, in fact, the scenario that was given as a hypothetical of when could a special permit be denied is actually present before the court, because this treed area is a vital resource.
Do you disagree with your brother's assertion that the landowner could clear cut all of these trees if the landowner so chose?
I don't believe this property is subject to any restriction that would prevent that, but I think that that is a little bit of a misleading road to go down, because what we're talking about is how may Petersham, how may a town regulate solar energy systems? And that has 2 points. We have the bylaw, which is plain, is not a ban or a prohibition either by its letter or de facto. And 2, we have the decision of the Board of Appeals, which lays out reasons that are in fact grounded in the bylaw. On the direct point, yes, but that does not mean that the ZBA, when considering a special permit application, throws everything in the bylaw in the zoning act and state policy out the window and says, well, you could do this anyway, why should we care?
Right, and I'm obviously not suggesting that, but it is not, for example, a situation where there is a proposal that involves removing vegetation from a state or local park, or a protected piece, or even a not protected, but, loved and used piece of public land. This is a piece of private land. Do you agree that 99% of the town is treed?
I think it was 97.5%. It's substantially forested.
Not a lot
I don't
of
know that I would
trees.
concede a particular percentage. And that goes to another point that's important here. The appellants are essentially arguing you can't focus on my particular project because it's only one project. And there's other land, and there are other towns and other cities. But the only way that state policy works is at the local level. If we always say, oh, it doesn't matter, this is just one project, and another project may be denied somewhere else, that only works until you get to the straw that breaks the camel's back.
I don't really hear them to be making that argument. I hear them to be arguing that the town has adopted zoning bylaws that permit the citing of projects such as this one in the town, assuming that the conditions, which are extensive in the solar energy bylaw, are met. And further, I hear them to argue, they have met those conditions, as was recognized by 2 out of the 3 members of the zoning board.
I would say 2 things. If you read the decision language of the 2 of the 3 members, it really does nothing more than parrot the bylaw. There are no particular types of findings that, if a special permit were appealed, would be sufficient, I would submit, to withstand scrutiny.
And that's okay under our law, right? Because you need to say a lot if you're granting a special permit, but really not as much if you're
Right, and
denying
that's
it.
my point. If you were going to rely on that, then I would submit that it's not sufficient. And then secondly, the appellants are saying that because the bylaw says you may only remove as much vegetation as is necessary for the project, then any size project is okay. So they're reading that
Well,
in...
no, it depends, of course, where it's cited still.
Yes, but the way it's being presented, their argument, if you carry it out, it doesn't matter how much land we want to clear, as long as we're only clearing the land that we want to put our system on, that's okay.
But that's what the bylaw says.
I would submit that the bylaw says the clearing may only extend to the extent of the project, but it does not say, and a project of any size is permissible. The appellants are reading that as carte blanche for whatever size project there may be.
Let me reverse that for a moment, because it seems like the dissenting member is saying 97% of this town is treed. Clear cutting of trees is contrary to the Clean Energy Guide and other protocols that have been established by the state. So, in other words, in practicality, nothing this large could ever be built because it would take down too many trees. Maybe, for example, a 3-acre or a 4-acre or something that's just over 1 megawatts, I don't know, might be fall within the category of being permissible as far as the board is concerned. But nothing that involves this kind of tree clearing would ever be agreed to. And their point is that that's a de facto prohibition. So what do we say to that?
To equate the position of one member in one decision on the only application that was ever submitted with the bylaw itself is a proposition that the appellant, I think, is suggesting, but there's no support in the law for that. And to have one decision be the standard or treated as the standard for any other application that might come after
in other words,
we don't have the
In other words, if we
facts.
were to disagree with the reliance on policy, et cetera, that this dissenting member has relied upon, and disagree with the judge who granted summary judgment, it's still just one case. It doesn't have anything to do with other cases. The only reason why this is an issue we're talking about future cases is because of this lengthy dissent that was written in which the member makes clear that tree clearing is a priority based on these other policy decisions.
And I would submit,
Right?
Your Honor, that we need to read that decision in the context that in which it lies. This is one application. One cannot, I would say, as the appellants are attempting to do, impose into the future or project into the future that this board with this member would never approve any project. If we had prior projects or contemporary projects.
Those projects are not before us. Correct.
Yes, and that's my point. To look at this in the narrow lens of one action amounts to a town or board position on all actions, on all applications, is to speculate far beyond the record. And the appellants have not identified by graphic or other means that there are no projects that could be permitted, even if we were to accept that this board would never allow tree cutting of a particular size of property. I think we just have too little of a record at this point to say that the action of this board in this instance constitutes
Then what do you say
a
about
prohibition.
their position that there should be no remand? That hypothetically, if we were to,
The argument there is, again, related to this. And the law is clear that public officers are presumed to act in accordance with their obligations.
do you think it would be futile or not?
I do not know. The membership of the board has changed. That's pointed out in the record. But I think we would be speculating, and I think we would deprive this board of the right that almost every other board has in a case like this, that if it is a first instance, that the court not grant relief without remanding to the board, and especially in the case where we had essentially a split decision, we now have new members, that even more so, I would submit, would deprive the ZBA and the town of the opportunity to exercise what Tracer Lane has said
Well, it's
is the
still a
right.
board of three, is that right?
Yes,
And so it's still, a unanimous decision still would have to be rendered.
that's correct.
And you
Yes.
said new members. How many new members?
There are two at this point.
So the only remaining member is the former dissenting member?
She's the chair, I believe, right?
Yes, yes.
Yeah.
If there are no further questions, I would conclude by saying the question in front of this court is whether protection of the environment falls within the penumbra of the interests that are protected under the concept of public health, safety, and welfare. And my brother referred to the statement of reasons citing quality of life concerns. I don't know how any of us could disagree that quality of life falls within public health, safety, and welfare. All of what we see, hear, and read about disturbance to our environment, to our residences, to our public and private spaces is how it affects us as humans on this planet, on a planet subject to climate change that needs to be protected. So resources that serve that protection are a vital resource. Thank you.
Thank you both very much. We'll take the case under advisement. Okay, we're going to hear one more case before we take our break. Okay with you? And that's case number 2023-1469, MEEHN SU GIM versus Young Investments, LLC, and others. I don't know. I didn't check. I can. I just look at my settings. I wasn't looking at anything with Wi-Fi. Case. I guess I am. But you need to look at something. Good morning.
Good morning, members of the panel. May it please the court, my name is Greg Assetto, and I'm here on behalf of the plaintiff appellant in this matter, MEEHN SU GIM. I want to focus on two particular issues that are of priority to my client. The two are the issue of the stipulation that was provided to the court and the testimony that was provided throughout the trial about the issue of who would be liable to repay the personal loans and advances of Mr. Lee. And the second issue that I want to focus most of my attention on is the issue of duplicative damages, which I would say are rife throughout this ruling. It was raised at the trial court, and the judge pretty much said take it up at the appeals court because there are several aspects of duplicative damages to discuss. So the first issue is the issue of the agreement that was made. And so I don't quite understand why the appellees are fighting this issue. It was told by the judge clearly to the jury in response to a question by the jury, and this is at the record appendix 2500. The judge specifically... Volume 5.
Thank you.
The judge specifically said, by agreement of the parties, I'm going to instruct you that there was uncontroverted evidence that any personal loans, emphasis provided by me, were to be paid back by the LLC or from Mr. Gim's share of profits and distributions. And that was in response to a jury question on the issue of when would the payment start by Mr. Gim to repay any advances that were made. That was the answer that was provided by the judge. So, on top of which, if you look at our brief, we laid out the multiple instances where the same issue came up, and it's footnote 3. Footnote 3, page 27 of the brief. I'm not going to read all of them, and I don't want to waste the time on that, but the case, the transcript is replete with references from not only Mr. Lee when he testified that he wasn't interested in collecting the money from Mr. Gim, that he wanted to be paid from the LLC, but Mr. Brooks said the same thing. In fact, he said in his closing statement to the jury, just to be clear, the agreement itself recognizes that Mr. Gim isn't in a position to make that payment back, so it doesn't contemplate him reaching into his pocket at the time. It talks about that it's going to be paid from future distributions from his ownership interest in the future.
So I'm a little confused about what the issue is here. It seems like there was agreement between the parties that was either acknowledged or endorsed, I'm not sure it matters, by the court as to what the method of payment would be. Yes. Do you have any case that, or any, statute or regulation for the proposition that part of a jury verdict includes directions as to how the verdict amounts will be paid?
No, I couldn't find any case law with regard to that, but I would say the case law on judicial estoppel applies here that says you can't make certain representations to the court and the jury, and then after you get a judgment for a certain amount, then not follow those instructions. So I anticipated, of course I didn't anticipate we would lose, but I anticipated if we did lose that there would be an instruction or some kind of a restraining order that the monies needed to be collected either directly from the LLC that Mr. Lee is the managing member of, so that could easily be done, or that an instruction that Mr. Lee was to pay himself from the LLC and document those payments because he was, as I said, the manager, so he could control that. So I certainly did not anticipate and do not think that it's fair and it's a violation of judicial estoppel that there's a representation to the jury that they relied on. Indeed, it was a question about it, and then the judge gave them instruction on, and afterwards turn around and say they can collect the monies directly from Mr. Gim, because in effect, if this judgment stands, they can now collect against him when that was not what was agreed to, and also...
I want to be very careful about what we're talking about, because
Yes.
the representation and, to my eye, the discussions that were that you cited in that long footnote, the record discussions about this, related to the repayment of personal loans
Yes.
made to Mr. Gim, which are part, but not all,
Most of yes.
what's been awarded.
Correct, yes, and I would say that the parts that are covered is the $4.2 million, and let me just flip to the verdict for a second. There's one other judgment as well, the breach of contract
as well for the $349,000. I argue that that is also part of this because the only obligation Mr. Gim had with regard to the operating agreement was to repay the monies that were being advanced to him. So the $349,000, I'm not totally sure where the jury got that number from, but it definitely had to arise from some advances that were made by Mr. Gim. Therefore, that's covered as well because it's any and all advances. And just to follow up, Justice Hershfang, on what you said, it's not just an agreement that was made during the trial. It's actually in the trial exhibits. It's in trial exhibits 7, 15, 21, and 39, and that's at the Record Appendix 86, 120.
Volume.
Volume 1. No, Volume 2, excuse me. Record Appendix 86, 129, 191, and 260. These are all trial exhibits. The first one is, it's entitled The Agreement Between the Parties, and it specifically says that Mr. Gim isn't going to be repaying any of these advances, that the company, the LLC, will be repaying them, or it will come from distributions to Mr. Gim. And the two promissory notes, which are trial exhibits 15 and 21, say the same thing. And the supplemental agreement to memorialize funds, is what it was called, trial exhibit 39, says the same thing. So throughout their relationship, before they ended up in court, the parties, there was an agreement that Mr. Gim was not going to pay, was not going to be personally responsible other than through the LLC. So there's no mechanism for Mr. Gim to be protected from that. If this judgment stands, he could then, Mr. Lee could proceed against him the day afterwards. And that's not the agreement that was struck between these two gentlemen, and it's not what was said to the jury. And I believe that this had an important value to the jury because they realized that there was lots of testimony. The record is replete with testimony that Mr. Gim doesn't have any assets, that he has nothing of value. And so the jury didn't view this as something that would impose a hardship on Mr. Gim because it would be paid from the LLC. So this was a significant aspect, especially given the fact the only question the jury had was about this issue of when Mr. Gim would have to repay the money. So this was a priority for the jury. And so moving on to the second issue, which is the duplicative damages, we raised this issue in a motion for remittitor and a motion for new trial. And there are several issues to this. So the first one I would say is your honors can determine exactly where the jury went to determine this amount of damages, the $4.3 million. It's actually a number that Mr. Ferraro, the defendant's expert, came up with. He testified about the total amount of the damages, which he said were all the advances that Mr. Gim made to Mr. Lee during the course of their relationship. And he also testified about what was called the advisory verdict, the $10,461,000. That number came specifically from Mr. Ferraro's report. And he's very clear that encompasses all the money that Mr. Lee laid out, according to Mr. Ferraro. And the $4.3 million, which is most important to my client, that's all the money that was advanced by Mr. Lee to Mr. Gim that Mr. Gim should be liable for, according again to the defendant's expert. So that's where those numbers came from, and it included everything. And so if you turn to the other counts in the case, those are already part of Mr. Ferraro's calculation. It's very clear that he included everything. So when the jury awarded the breach, for instance, the breach of contract, the $349,000, Record Appendix 82, that money was already included in the $4 million or the $10 million. And so there's a duplicative award. And the case law that I cite very in detail in our brief sets forth that you can't recover twice for the same harm. It would be unfair and inequitable. And so if this is allowed to stand the way it is, Mr. Lee would recover twice for the same damages in this regard. Likewise, in the breach of fiduciary duty area, the breach of fiduciary duty, as far as I can tell, and it seems pretty clear from the record, the breach of fiduciary duty was in the amount of $350,000 against Mr. Gim, was related to the Porter Square Hotel. Now, the $350,000, the only time that number came up during the entirety of the trial was this issue of Mr. Lee asking Mr. Gim to consent to a low-interest loan of $350,000. And in fact, in the jury verdict slip, the judge included, over my objection, I believe, that this reference to, and it's the bottom of Appendix 80, page 85, of the verdict slip. They're not, in this page 8 in the verdict slip, 085, the record appendix. It says specifically, failed to cooperate in efforts to obtain low-interest loans to fund the operation of the Porter Square Hotel. So that was one. There are multiple aspects that are listed under breach of fiduciary duty, but that's the one I say that the jury must have relied on because that's $350,000.
Well, but, I mean, that's one of a number of, right? Caused delays in construction, failed to contribute towards operational expenses, the one you mentioned, failed to honor his contractual obligations, insisted on monthly payments of $10,000, and/or failed to honor his contractual obligations to the defendants. So there's 6 possible fiduciary obligations listed in that question, and the jury responds yes. The jury doesn't circle or underline any particular one of those. So I understand your sort of reasoning by, deduction, but that's not, I don't think that's what we do with jury verdicts.
Well, I'm drawing an inference from the fact that they came down to $350,000, which is the exact amount that Mr. Lee testified about that he wanted to borrow. So that's the conclusion that I drew. But more to the point was that the jury then went and divided it in half and awarded damages to Mr. Lee. Now, there's 2 members of the LLC, and so the jury awarded damages of $350,000 to the LLC and then awarded damages to the half-owner member of half of that amount. And it's duplicative because Mr. Gim is not only recovering because he's the half-owner of Porter Square Hotel LLC, but he's also recovering the $175,000. So this is another duplicative aspect that Mr. Lee ultimately is recovering twice for the same damages. And I submit that that is also a violation of the law in that area. And lastly, on the fraud and misrepresentation claim, so the fraud...
I want to pause for one moment on the fiduciary duty issue. In terms of whether it was raised below, where did you argue in the trial court that Mr. Gim's fiduciary duty was circumscribed by the parties' operating agreement? Not Mr. Lee's, but Mr. Gim's.
I'm not sure I understand the question.
So one of the arguments that you make to us is that the extent of the fiduciary duty that your client owed to his partner is limited by terms of the operating agreement. At least I thought that I read that in your brief.
Yes.
Is that an argument that you made to the trial court?
Well, I don't think it was an issue at the time, no. So I don't think I raised that specifically.
Okay. Well, there was a counterclaim, right, for breach of fiduciary duty.
Yes.
By Mr. Lee against your client, so that was a live issue at trial.
Correct, and so the obligations are circumscribed by the agreement itself or some other case law, but the case law was not argued to the jury about other responsibilities. It was just the operating agreement that would have established Mr. Gim's responsibilities to the fiduciary duty to the LLC. There was nothing else provided to the jury in that regard.
So your position is that a fiduciary duty doesn't have any sort of legal meaning out there in the world. It's only whatever the parties agree to in a contract.
No, what I'm saying is that the judge instructed them, did they breach the fiduciary duty, and what was before the jury to consider was the terms of it wasn't just one operating agreement, there was several different agreements, as Your Honor probably has seen.
Yep.
Multiple agreements, and the judge instructed them to consider the obligations, but I don't think there was anything else provided to the jury to determine. In other words, there was no instruction that described specific obligations that Mr. Gim had. There was a definition of fiduciary duty, but it didn't say he has a duty to respond promptly to Mr. Lee or something.
Act in the utmost good faith.
Yes. Yes, but what I'm saying is the specific obligation that he thought he had a role to manage the restaurant and to do operations. He was removed from all of that by Mr. Lee. So the only other obligation left to him was to repay the loans as set forth in the terms of the agreement. So there wasn't any other obligation that the defendant could point to that Mr. Lee violated, I believe. Excuse me, Mr. Gim violated. but I did want to talk, but I'm running out of time, about the fraudulent misrepresentation. So that claim specifically says to the question to the jury was, do you find that Mr. Gim made fraudulent misrepresentations to Mr. Lee contemporaneous with the signing of the September agreement? Now, that is a representation about his financial debts, that he misrepresented them. Now, the jury obviously found that to be true, but that money was awarded in the $4.3 million. Those amounts that Mr. Lee says Mr. Gim didn't disclose are in the $4.3 million. So again, it's a typical situation that we have after trial. If you prevail on the contract and you prevail on a tort claim, you don't ever get both of them, because it's a windfall to the plaintiff in that case. You get one or the other, and the judge decides what's fair. That's what I'm seeking from Your Honors. I know I'm out of time now.
Well, I gave you an extra 45 seconds or so since you answered some of our questions, but you'll have to leave it with your brief at this point.
All right, thank you. And I will rest on that unless there's any other questions. I'll rest on my brief. Thank you, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court. Doug Brooks for appellees. So in terms of the two arguments that appellant's counsel really focused on, so on the first issue, the one about the personal loans, the repayment, I think, and I'm still not clear what the remedy is that they're seeking. I'm not hearing that they have an issue with the jury's finding that Mr. Gim breached the contract. They're not saying that the jury got that wrong. And so the judgment simply adopted the jury's verdict. It didn't do anything more or less than that. In the papers, what I thought the argument was, but I'm not sure, is that they were saying that the agreement, there was certainly an agreement, but the agreement's not a limitation on liability. It wasn't to say that Mr. Gim isn't personally responsible. The idea was simply, it went to the timing. It simply was that, does Mr. Gim owe the money for the personal loans? And the answer was yes. And the agreement, simply because that was the agreement of the parties, was that it was always understood that the money would be paid back through Mr. Gim's distributions from the hotel. That's different than a limitation of liability. And I think some of the confusion just stems from the fact that they made a similar argument below in their motion for JNOV or for a new trial, but it wasn't the same argument. What they argued below was that the agreement was that Mr. Lee was not looking to recoup the monies from the personal loan. So that's a different argument than they're advancing. So really what's happened here is the trial court just didn't make any findings on that. So, I mean, to be candid, I think we're, again, where it goes to is I'm not sure what the remedy is, because there is an agreement that the money will be paid.
I think the remedy is he says that he doesn't have to pay the money because it's supposed to come out of the LLC and not him personally.
Well, well, that was never the agreement. The agreement was always that it would come out of his personal share of future distributions and profits, which is different than saying it's coming out of the LLC.
Okay.
Although eventually it's sort of from the same thing. It's coming out of the LLC for whatever. I mean, I know it's outside of the record. That's still the plan. So in some ways, I'm not sure exactly what we're fighting on. There's a judgment, and it will be collected when it will be collected by Mr. Lee through future profits and distributions.
I want to, on this note, I want to ask you about something you said at trial. So this is Record Appendix 5, page 2557. You said, we did say that he, Mr. Lee, is not pursuing Mr. Gim personally for any loans, that they would come out of future distributions. However, the jury found damages above and beyond that, and so that's not subject to any kind of agreement. We just never discussed that. So as I read that, but you're the guy who said it, you're making a distinction between, I don't even want to call it an agreement because the suit was a violation, was breach of contract, among other things, right? So to be held to the contract after you've sued for breaching it seems a little weird at best, but some kind of agreement between the parties that contract damages would flow from future earnings, from Mr. Gim's future earnings from the LLC. But you seem to me in this section to be making a distinction between repayment of the loan and damages for fraud and breach of fiduciary duty.
Yes. I would not be being honest if I could tell you I specifically remember making that comment, Your Honor, but hearing it now and reading it in preparation for that, I am 99.9% certain that that's what I was doing. I was making the distinction between count 1, which went to the loans, the personal loans, and then the damages on top of that that the jury awarded, which I guess just flows nicely into the second issue, which is duplicative damages. Again, this was not raised below, and so we don't have findings from the trial court. They did raise, Mr. Gim did raise a different duplicative damages claim that he's now abandoned, so we don't have the benefit of the trial court's deciding in his post-trial memorandum whether or not there were duplicative damages. But I just say that even beyond the sort of that waiver, the waiver that they didn't make this argument below, is that Mr. Gim didn't object in any way to the jury instructions on duplicative damages. There was sort of, I think it was the standard, just one sentence on, hey, you can't award duplicative damages. But more importantly, Mr. Gim didn't object to the verdict slip. So the onus was on him. If he sees this potential, now he's saying that he believes that all of the damages for breach of fiduciary duty, fraud, there was another one where they awarded 0 on implied covenant, but if he thought that if there was a chance for those to be duplicative, respectfully should have objected to the verdict slip and perhaps, either said something along the lines of, if you find that a contract is, breached, you must find 0 damages on the others, or have the jury, there was a special verdict for him, include from the jury, how are you coming to this damages? As Justice Hershfang said, on the breach of fiduciary duty one, for instance, the $350,000, simply guessing, there were 6 or so different breaches of fiduciary duty. Now, what Mr. Seto said is, well, I think it's probably this one because the numbers add up. I wouldn't disagree with that, might be, but we don't know. And the jury's been discharged, and again, if that was going to be an issue, it needed to be something that was dealt with at the trial court level in the special verdict form. So I think at this point it would just be pure speculation. Even if it's informed speculation, it's still speculating as to what the jury did. And at this point, we really don't have any idea other than trying to put ourselves in their position. And I just think the time's too late for that. The other issues, I don't know if I can go through quickly. Mr. Seto ran out of time. There were certain things, that, for instance, on his affirmative claims that they argue in their papers that Mr. Gim could not have breached his fiduciary duty by failing to sign for a loan for COVID, and their argument is that, under the agreement, if he thought something was imprudent, then it didn't breach his fiduciary duty. And while that's true, the jury obviously found that that's not why he didn't do it. The judge addressed that. Similarly, with the breach of the restaurant agreement, This one was raised and was squarely decided by the trial judge post-trial, which is said that that no jury could have found that Mr. Lee didn't breach the restaurant management agreement, but there was evidence that Mr. Lee put forward that 1, Mr. Gim didn't perform under that agreement, and 2, that he signed on the same day another agreement that was inconsistent with this one, and he intended that to be binding. And again, those were just jury questions that the jury ruled in favor of Mr. Lee. Unless the panel has any questions, I'll rest on the papers.
I don't see any questions. Thank you both very much for your argument.
Thank you, Your Honor.
All right, so the court will take a 15-minute recess. Thank you.
All rise.